A disturbing case out of Arkansas. A married couple now behind bars facing serious charges for the alleged sexual abuse and drugging of a girl. Authorities say the abuse spanned over several years and involved repeated sexual assaults and physical violence. I'm Kennedi Walker, and I'll walk you through the charges, the alleged timeline, and what the victim is now revealing to investigators. Police say these are the mugshots of Annie and Daniel Collar, a married couple now accused of physically and sexually abusing a girl for years. Photos on social media show them smiling and appearing happy, but according to investigators, the allegations are anything but. Bentonville police say the pair forced the girl to sleep in a bathroom and only allowed her one Pop-Tart and one glass of water per week. She told investigators that Daniel Collar raped her multiple times, with the first incident allegedly taking place in 2020. According to the probable cause affidavit obtained by Law&Crime, Annie Collar allegedly walked in during one of the assaults, and Daniel yelled at her to get out. The next day, Daniel reportedly threatened to kill Annie if she reported what she saw. The girl told investigators that threat scared her, and that's why she didn't tell anyone. She said the abuse continued at multiple homes across 2 counties in Arkansas. According to the affidavit, Annie allegedly caught Daniel raping the victim again in March of 2023. The girl told police Daniel dragged her by her hair and assaulted her in the living room. The victim said she yelled no and begged him to stop, and Annie allegedly intervened, grabbing her and pulling her away from Daniel. The girl also told investigators that the couple regularly abused her, pushing her into walls, punching and kicking her, and refusing to get her medical help when she was hurt. In one instance, the victim said she broke her leg, but Annie and Daniel allegedly refused to take her to the hospital. She also described an incident where Annie allegedly stabbed her in the neck with a fork after saying she hadn't done the dishes correctly. According to the affidavit, Annie then told her, "I hope you die." Investigators say the abuse didn't stop at violence. The girl told authorities the couple also forced her to assist in drug deals and made her use drugs herself. She says she was exposed to fentanyl, cocaine, methamphetamine, and other substances. Despite reportedly telling Annie she didn't want to take the drugs, the girl claims she was forced to snort them at least 4 times. Authorities say she eventually confided in a school counselor and contacted police. Annie and Daniel were arrested. Daniel is charged with rape, terroristic threatening, endangering the welfare of a minor, sexual assault, and permitting abuse of a minor. Annie is charged with introduction of a controlled substance into the body of another person, permitting the abuse of a minor, terroristic threatening, battery, and endangering the welfare of a minor. And joining me to talk more about this is criminal defense attorney Josh Kornman. Josh, thank you so much for coming on today.
Thanks for having me.
So let's get right to it. We see both the husband and the wife have been charged with a slew of aggravated assault, endangerment. Can you break down what those charges mean and how many years they could be facing if convicted?
Sure. So, from my understanding, I think the husband Daniel is charged with rape. That's in Arkansas. That's called a Class Y felony, which means that carries 10 to 40 to life in prison. So that's the most serious in Arkansas is a Class Y felony. They've also been charged with terroristic threatening, endangering the welfare of a minor. Those are Class D felonies that carry up to 6 years. The sexual assault charge in the second degree is a B felony that carries 5 to 20 years. And permitting abuse of a minor is a Class B felony that, again, also carries 5 to 20 years. I think the other most serious charge was the introducing a controlled substance into the body. That's the most serious charge that Miss Kohler is charged with, and that again is a Class Y that carries 10 to 40 to life, depending on the type of drugs. And I believe so if it would have been methamphetamine, it would be a Class Y felony. I think if it's a lower class of a drug, then it could be a lower charge, but it looks like from what they're charged with that it would be a Class Y felony.
Yeah, the victim is alleging that they gave her drugs like the methamphetamine, fentanyl, cocaine. So if multiple drugs, could they be charged like for each drug?
In theory, they could, and at some point in time, this is the original charge. Those charges could be amended, or I guess when the case gets higher in court, if it's indicted, then yes, they could add additional charges as the prosecutor sees fit. So the original charges aren't always the charges that will stick. The prosecutor will have some discretion to choose additional or different charges as the case goes forward.
And the abuse, it allegedly spanned several years. Does that time frame, that long pattern of behavior, make a difference in how prosecutors pursue this case?
I think it does. Oftentimes, you will see that, and certainly in child sex cases, is that the allegations will occur over a long period of time. Very often in sexual assault cases, but especially those kind of cases with kids, is a minor may not make the accusation or may not make a disclosure of abuse until sometime later. And there's always discussions, with the Diddy trial or a bunch of other high profile trials where there have been victims that have come forward after, 10, 20 years. It's not uncommon at all in sexual assault cases for victims to delay a disclosure of abuse, and then the prosecutor has to make a decision of which charges the statute of limitations haven't run on, or how to basically do the time period for the charge. And normally the law allows for a pretty extended time period, so it will not give a specified date of, a rape happened on, June 20th of 2022 or something like that, but it will give a time range that would cover basically cover whatever the charges is, so that when you get to a trial, the jury, I guess, is open to consider multiple acts that would have occurred during that time period in the indictment.
Do they do that because of the trauma? Because we know in many of these cases, trauma can impact memory. So if the girl's story changes over time, that couldn't hurt the prosecution's case, right? Since we know that, this day and age, a lot of victims, they don't feel safe coming forward.
Absolutely. So I think trauma is part of it, and then the other part of it is, certainly when you're talking about a child. And again, I don't know exactly what the age of the alleged victim in this case is, but when you're talking about children, they don't, keep dates the same as us. They don't think about time the same way that adults do. So sometimes they can narrow it down to a place that they lived, or maybe what grade they were in school, or they can remember some significant event that it was, during Christmas break or during summer vacation, while they had Miss So and So as their teacher. But it'd be very difficult if they were forced to give a specific date and time of when an act happened, especially when you're talking about something that occurred many times over a long period of time. And so that's why the law allows the prosecutors to file these types of charges with a very wide date range.
Right. And we can't say enough just how traumatic, incidents like this can be. How important is her current physical and emotional state when it comes to preparing for a trial?
Well, it's going to be very difficult for both sides. One of the things that I would imagine is going on right now is she's probably going through counseling. There's victim witness coordinators that work for the prosecutor's office that are probably arranging so that the prosecutor can have different times to meet with her, try to build rapport and prepare for a hearing or prepare for a trial. And then those are obviously things that the prosecutor's office is going to have to consider going forward. Is she going to be able to testify at a trial, or how will she do at a trial, or is the trauma too dramatic for her to be able to successfully testify at a trial? And those are things that both sides, the defense and the prosecution, are going to have to weigh as the case goes forward and they make an agreement, whether it is going to go to a trial or there's some kind of a plea that's going to be worked out.
And let's talk about proving these kinds of cases. Without physical injuries or DNA evidence, how do prosecutors build a strong case in abuse allegations like this?
So they're difficult, right? And it's difficult for both sides. One of the difficult things I'll say being a defense attorney is you realize how easy it is to charge someone with a crime like this. Someone can just come out and say, hey, this happened to me, or this has been going on. And there may not be, especially in child sex cases, there may not be any other evidence, no physical evidence, like you said, no DNA, no witnesses. Rarely is a child going to be molested by somebody leaving witnesses. I know in this case, the two co-defendants certainly would have been witnesses of whatever each other are doing, but no other independent witnesses to corroborate that. So it really does come down at a trial to the jury, and does the jury believe the victim? Do they believe whatever the victim is saying? So anything that can be used to corroborate or to show that something is not true is something that both sides are going to be working on. The prosecutor obviously is going to try to find anything that could corroborate the story, and certainly the defense is going to be looking for anything to show that any part of the story is not true, to try to prove that the victim is not reliable, and the jury shouldn't find her credible.
And both of the suspects, they are both locked up right now. But what if one of them talks or turns on the other? Could that lead to a plea deal for one of them?
It certainly could, and I would imagine that that's something that's going to be discussed by both sides. Anytime you have co-defendants, that's always an issue of is one of them gonna roll on the other, so to speak, or is one of them going to cooperate with the government and end up testifying against the other in exchange for some kind of leniency in their case. So in a situation like this, I would imagine that that's certainly going to be contemplated by both the prosecutor and the defense attorneys, and then I guess it just comes out, later on how that will actually come to fruition. But in every case, anytime there's co-defendants, that's always going to be a consideration.
And let's say the wife claims she was being abused too, that, maybe she was under the husband's control. How does the legal system treat claims of coercion or fear when someone is accused of being part of the abuse?
Right. So I think the first part of it is goes back to prosecutorial discretion, right? The prosecutor really has the complete control of how a case is handled. They're the ones who brought the charges to begin with. So they're the ones that can make a decision whether they're going to agree to reduce those, dismiss those, or make some kind of a plea agreement. So if in fact they come to believe that yes, the wife had been, victimized herself, or she was being coerced to do things, then certainly that's something that a prosecutor could take into consideration when they decide how they're going to negotiate the case. Otherwise, you're right, that's something that would come up in a trial, for instance. The defense may be arguing to that she didn't do any of those things willingly. She also was a victim herself. She was being abused, however, or drugged, or whatever that theory of defense may be. That's something that could come up at a trial if the prosecutor hasn't already taken those things into consideration to give some kind of a plea bargain or a reduction to that co-defendant who's cooperating.
Yeah, because I know according to the affidavit that I read, it says that one of the times that the victim alleges that she was sexually assaulted by Daniel, that Annie did step in and, removed her and broke it up. But
Right.
is that still a defense for Annie? Yes, she did, allegedly break them apart or, made Daniel stop. But at the end of the day, it was never reported. Annie never reported or called 911 on her husband.
Well, not only sounds like she didn't report it, but then she didn't do anything to, I guess, prevent that from happening again, or take whatever measures were necessary to protect the child. And I think that's where some of those other charges come from, which was one of them is permitting abuse of a minor, or endangering the welfare of a minor. Those are the types of things where a parent, a guardian, or some kind of legal custodian obviously has an obligation to protect and care for a child. And when that does not happen, or they allow something to occur, and that whatever those events are could cause bodily damage, bodily injury, or death, or something like that, then that's where those types of charges come from. And so I assume that was the reason for both of them, that they have included charges of permitting abuse, endangering the welfare. And again, those are also serious felony charges that by themselves could carry quite a bit of time.
From a legal standpoint, what kind of experts are typically brought in to testify in these kinds of trials?
So the first one I would assume would be someone from the Child Advocacy Center that the victim would have done an interview with. Most of the time for child sex cases, they will go, besides speaking to police, they will go do an interview at a Child Advocacy Center. Those interviews are recorded. There's no one in the room except for someone who's a forensic interview, who is an expert, so to speak, or who is specially trained in talking to kids. And they are, by training, they are neutral, and they're not asking leading questions. They basically just give an arena for a child to disclose whatever it is that they want to talk about. And by law, those things can be used in court. They can be played in court, because you never really know how a victim is going to react in the courtroom under cross-examination, or just the fear of being in a courtroom in front of a bunch of strangers. So the law allows those video interviews to be played in a trial. So I would assume that's something that has probably occurred while this case is being investigated. Um, the other types of experts obviously could be experts about the injuries. You may have somebody from children's services testifying. I guess an expert isn't necessarily somebody that we think of, like a firearms expert. They just have some kind of knowledge that would be helpful to a jury. So that being said, there could be all kinds of different experts or all kinds of witnesses that would be called to give testimony in a case like this. Certainly, there could be medical personnel if there was like some kind of a rape kit done or an examination by a nurse who does those kind of examinations as far as any injuries, or if there are not injuries. A lot of times, those witnesses will even explain the lack of injuries and what that should mean to a jury.
If you were the suspect's attorney, how would you go about arguing this case?
Well, I think the first is one of the questions that I don't know yet is who the alleged victim is to these two individuals that are charged. Obviously, from the charges, they had some kind of legal custody or guardianship or something over them, but it doesn't ever state that it was their child or their daughter. So that's the first thing is I would try to figure out is who that person was or why they were in their custody to begin with. If these were foster parents or if the state had given custody or guardianship or something like that to them, then there should be other reports. There would be some documentation or something to show why they were in their custody, when they came in their custody, and if there were other issues or problems with that child before they came into their custody. I think that would be important. The other thing is, when we go through in cases like this, you really do with a fine-tooth comb, you try to go through and pick every detail that someone gives, and you try to do whatever you can to either corroborate or to show that any of those details are not true. And on the defense side, hopefully the more details that you can show that are not true or exaggerated or impossible, that's going to affect the credibility of that witness and any witness anytime that they're testifying.
We know trials can take months or even years in some cases. What's the typical timeline we're looking for here?
So I'm not exactly sure in this jurisdiction in Arkansas how quickly the case would move from this type of arrest to a trial, but generally I would think that somewhere between 1 and 2 years from the time of arrest until you actually get to a trial is probably a pretty good guess in most jurisdictions, especially on serious charges like this. In some jurisdictions, obviously, they're going to move very fast, and maybe within a few months, you would have a trial date set. But I would imagine the discovery in this, the evidence to be reviewed, is probably going to be pretty extensive, which is going to take some time. And like any other jurisdiction, just depending on how backed up the trial schedules are, that's going to also dictate how long it takes to get a trial date.
Well, let's just flip the scenario for a second. What if either of them is found not guilty? Does the state have any civil path to still protect the girl or hold the adults accountable in another way?
Yeah, so I think that's a great point. So normally in all of these kinds of cases, anytime there's physical or sexual abuse allegations, there's two investigations that are going to take place, and the DCS part or the Children's Services part of the investigation is going to go on a different path. So regardless of whatever happens in a criminal case, there will be a different judge, different hearing, different parties to any allegation of abuse. And in those situations, in the civil part of the case, the I guess instead of a guilty verdict, whether someone believes that you're criminally responsible for an act or not, the issue really becomes what is in the best interest of the child. And so, regardless of what happens in a criminal case, a separate judge, separate attorneys would be making a decision of what's in the best interest for this child. And I would imagine, and it's a lower burden of proof as well. So that would be easier to prove that these two people should no longer have any kind of custody, visitation, or contact with the alleged victim. So regardless of the criminal part, I think it's probably very likely that this child would never be back in the house with these two people.
Right. And according to their social media pages, it appears as if the suspects have younger children. Since they both are, have been locked up, what happened to those young kids?
So again, Children's Services would get involved kind of at the first instance, and they would make a decision for where the other children would go, whether that goes into foster care and state custody, or even if they do go into state custody, normally Children's Services is going to try to find a family member where they would go, and I guess, stay with a family member while this case goes on. And that family member usually will also have conditions. They'll have to do a home visit to make sure it's a safe place. They will continue to follow up to um, keep an eye on, make sure there's services for the child who's in any other family, and then ultimately see if that family member is someone who wants to then get legal custody of the child as time goes on. So that's generally how those occur, and hopefully in a case like this there were other family members, and those family members are protective of the kids.
I know this trial hasn't started yet, but can the victim sue the suspects in civil court later?
Sure. So there could always be a civil suit that may follow a criminal case, and you see those all the time. The issue becomes when you're talking about a civil lawsuit. Civil lawsuits are all about money, and in a situation like this, I don't know if the defendants actually have money where it would make it worth an attorney's time to try to file a lawsuit. So the way civil attorneys get paid is they are going to get a percentage of whatever the party wins. So if you just think of cases like like an auto accident case, right, where someone gets hurt from an auto accident, the attorney is going to sue, and if they're able to settle, they're going to take a percentage of whatever they win. But if someone doesn't have any money, then it's hard to collect whatever that fee is. So while yes, you could certainly file a civil suit, I don't know if this situation is something where they would have any money to collect on, which then again gets back to whether an attorney would actually take the case and file a suit, because there may not be anything financially wise, money wise, there may not be anything to win.
All right. Well, this is a case that we will be following closely. Josh, thank you so much for coming on today.
Absolutely. Thanks for having me.
Daniel and Annie will be back in court next month. For Law and Crime, I'm Kennedi Walker.